Your Honor, if it pleases the court, my name is Nathan, first initials KC, and I appear before the court for the applicant, Mr. Marshall Ike. Your Honor, I wish to appeal the evidence under Section 590AA of the Criminal Code, which was obtained by the police during the prosecution of my client. There are 84 counts of breaking and entering and 1 count of stealing against my client, which the Crown is seeking to admit. I would like to bring to attention that my client is a 14-year-old juvenile from the Torres Strait. Your Honor, I would like to address the issue of admissibility of evidence with regards to the procedures under Police Powers and Responsibility Regulation and the Police Powers and Responsibility Act, which have inadvertently been contravened by the police who were present at the time of my client's prosecution. If I may, the police at the time of the interview had breached Section 418 of the Police Powers and Responsibility Act 2000. Based on facts, Your Honor, Mr. Ike was not informed by the police that he had the right to call his parents or guardian throughout the whole ordeal, which is a breach of Section 418, subsection 1A. The police did not adhere to Section 23 of the Police Powers and Responsibility Regulations on advising my client that he could speak to a family member or guardian. Under Section 392 of the Act, police must immediately notify a parent or guardian about the arrest and the whereabouts of the child. Yet again, Your Honor, based on the facts, the police failed on this aspect, and my client told me he had no contact with his parents through the entire arrest. The police had breached Section 421, subsection 2A of the Act, as my client, who is a child, should have been questioned by the police without allowing him to speak to a support person of his choice first. My client should have had the right to have a lawyer, family or friend when being questioned, and also prior to being questioned. During the police car ride to the police station, Mr. Ike was interviewed by the police, whereby he was not provided with a support person then. On top of that, Mr. Ike had an unknown support person present at his interview. My client did not choose to have that support worker present with him through the interview. She was simply allocated to him. Your Honor, let me restate the fact that this support worker was unknown to my client. Respectfully, Your Honor, I have many concerns regarding this issue because keeping in mind that my client is only a mere 14-year-old minor, should not have yet had a parent or guardian with him. The police present in the interview did not comply with Section 26 of the Police Powers and Responsibility Regulations, through which they did not make known to my client that he had the right to remain silent. My client mentioned that the police did not tell him something along the lines of, "Before I say anything, you have the right to remain silent. This means you don't have to say anything, answer any question, or make a statement unless you wish to do so. However, if you do want to say something, it could be later used as evidence." Furthermore, the support worker who was with Mr. Ike gave him the advice of, as I quote, "Well, just make sure that you answer the questions the police ask you." This, I perceive, was one of the reasons why my client simply answered yes to every question. Your Honor, as my client is of Torres Strait descent, Section 420 of the Police Powers and Responsibility Act applies. According to the law, a police officer who is aware that the person is a Torres Strait Islander must inform the person that a representative of a legal aid organization will be notified. As of Section 420, subsection 3, Section 420 would not apply if the person in custody for an offense is not disadvantaged. At the time of the arrest, my client had made known to the police of his cultural background. In this case, Mr. Ike is obviously of a disadvantage because he's a child. So why was he not given such opportunity to contact relevant legal aid? My client, being of a Torres Strait background, has a cultural tendency to agree to questions given to appease the police, even if he would not have agreed with them. This cultural tendency, gratuitous concurrence, should have been taken into consideration when the police used every word that Mr. Ike said as true evidence. My client would have been better off if a support person could have helped him understand the questions during the interview. Your Honor, according to Sections 436 and 437 of the Police Powers and Responsibility Act, there could have either been an audio or video recording during an interview, and based on the facts, indeed there was one. However, according to Section 439, the court has the power not to admit the recording. In this case, as there has been several proofs of non-compliance by the police during the interview, which was a breach of, let me list, 392, 418, 420, and 421 of the Police Powers and Responsibility Act, and Section 26 of the Police Powers and Responsibility Regulations. Due to all these incompliances, I humbly ask, Your Honor, if you could dismiss the evidence of the police recordings under Section 130 of the Evidence Act, mainly since the police had not complied with their legal rules when obtaining the evidence in the video. If the court pleases, I'd like to establish the case of the Crown and Christie, such as to exclude admissible prosecution evidence, which, as I quote, more prejudicial than probative. Since such evidence from the recordings were technically illegally obtained by the police, it's only fair to my clients to dismiss the evidence provided to the court by the police. To reiterate this issue, my client was not aware of his rights, and the police had failed to make known of his rights. The police did not ensure fairness to protect my client's rights, which is another breach of Section 5 of the Police Powers and Responsibility Act. As mentioned in Bunny and Cross, it is society's right to insist that one who enforces the law themselves respect it. As stated in the Crown and Scarce, the purpose of this discretion that I humbly ask for is in the protection of the rights and privileges of my client, including procedural rights. Your Honor, my client's case relies greatly on the evidence submitted by the police, and I formally request a fair dismissal of this evidence against Marshall Ike under Section 590 AA of the Criminal Code. As Your Honor pleases.